Hello, Mike Moore here, your Lightspeed litigator, breaking down decades of trial experience into brief and useful insights to help you persuade. I was working on preparation for the defense of a deposition of my client, a plaintiff, and it struck me of my concerns about the three most dangerous deposition questions for a plaintiff, and I thought I'd share those with you today. You know, when the deposition commences, your plaintiff is full of anxiety and fear about the process, no matter how well you've prepared her, and she's most vulnerable at that beginning of the deposition. Obligingly, however, in my experience, defense counsel have spent the first 20 minutes or so of 99% of the depositions I've defended in throwing softballs at the client, so that by the time they cut to the heart of the claims, the client is better prepared, more relaxed, and more confident. That, however, is changing and will change dramatically in the future. So let's talk about the first question that is of great danger, in my opinion, to the client. And it's very simply this: client has been introduced, raised her hand, swore to tell the truth, given her name. Defense counsel immediately hands her the complaint in the case. Ms. Smith, I'm handing you Exhibit A, which is your complaint in the case. What evidence do you have that Officer Jones violated your Fourth Amendment rights? Now, no preamble, no opportunity to get comfortable, and right off the top, what would be an objectionable question in any event. Yet your client in a deposition must be prepared to answer that question. So that's question number one, the most dangerous in my opinion. It's dangerous throughout the deposition, but it's most dangerous here. The second two lines of questions, which I consider extremely dangerous, relate to damages. And interestingly enough, again, in my experience, 99% of the defense lawyers never even cover these areas. However, that's going to change. This is a book by Robert F. Tyson Jr., defense counsel, Nuclear Verdicts, directed to the defense bar and teaching them how to eliminate unreasonable plaintiff's verdicts. Okay, the two questions, and he confirms to me my fears here. The two questions. The first question, excuse me, if you have an ad damnum clause in the complaint with a number, the question is very simple. Ms. Smith, you have asked for X millions of dollars from my client. Tell us how you calculated that amount. Client must be prepared to respond to that. If you don't have the ad damnum clause, I'm in federal court, I don't put one in. But it's, Ms. Smith, tell us how much money you want from this jury. Tell us how much money you believe you should be awarded. And if the client puts a number on that, then the next question is, tell us how you calculated that number. The final series of questions of great danger, in my opinion, follow from a series of questions in which your client's financial condition and income is explored. And then it's followed up with this question. You have testified, Ms. Smith, as to your mortgage, your debt, your student loans, your credit card balance. You've testified that your children are in charter school and you pay X dollars in fees every month for those children. Now, would you not agree with me that if you came into X dollars today, and those X dollars, of course, are a fraction of what's the ad damnum or a fraction of what you as the plaintiff's lawyer will be asking for to the jury, agree with me that sum of money will pay off all your obligations and free you to move on with your life. You agree with me on that, right? Again, whether this question is ever asked or not at trial, in the deposition, it must be answered in some way, and you must prepare your client to be able to answer that question. So, the three most challenging deposition questions for a plaintiff. I urge you to consider this and to frame your preparation for your plaintiff to be able to respond to those questions. Thanks for your time. Talk to you soon.
Our goal with this series of shortcuts is to start a conversation. Your comments, criticisms, and your own experiences in persuasion are most welcome.